Hi, ladies and gentlemen. Thank you for tuning in to Seek Elevation with Alakisha, where you will get tips, strategies, and motivation to elevate your business and personal life practices from one of the most empowering attorneys, speaker, author, and advocate in the sport of life. So with no further delay, let's get to today's enlightening topic. Welcome to another segment of Seek Elevation with Alakisha, where you will get tips, strategies, and motivation to elevate your business and personal life practices from our 15-minute discussions on various topics to elevate your mind. We can discuss topics that are relevant, hot topics, business related, or I can share legal tips. With that said, let me give my legal disclaimer. Anytime we do touch on a topic and I am sharing legal tips, these are nuggets that I'm giving you to expound on. This is not me being your legal representation. It will be impossible for me to do that unless I knew your specific issue, your specific situation, and you hired me to do so. So what I am doing is giving you information, hopefully to enlighten you, to nudge you to find out more about whatever the information is that I'm sharing, and hopefully hire someone to give you more information about whatever we have covered within that 15 minutes or less. So with most people, disclaimer is they are not an attorney, although they may touch on some legal topics. I am an attorney. I am an attorney that provides services to entertainers, athletes, and entrepreneurs. Specifically, I guide and advise them and empower them in contract dealings, intellectual property, which is trademark protection, copyright protection, and making sure that they are in state and federal compliance with their business from conception to maintenance. So that is what I do. Those usually are the topics or tips that I usually give when I incorporate it into whatever discussions that we have. But they can range. As I stated, our 15-minute discussions can be business related or personal life practice related, which I see them both one and the same, because whatever you do in your personal life practices will affect your business. Whatever is going on in your business will affect your personal life practices. So for those who may be listening for the first time, I am on segment 28. So if you haven't heard the previous 27 segments, I highly encourage you to do so. You can listen to them in any order. They are all standalone, but the one thing that each segment has in common is that it is to empower you with the information that is shared. So for my ascenders who are always seeking to rise higher, to higher vibrations, what we do is delve into a topic for 15 minutes or less. Sometimes I may go over 15 minutes and I do start a timer and I have the discussion. Once the timer starts, the heart of the discussion, and then when the timer ends, that's where I will leave off, and I may pick up at a later time. I may leave it just where it is at, but sometimes I may want to just, that topic was just so good. I want to finish a thought, or I really have to give you whatever I need to give you in that time. So we may go over 15 minutes a little bit, but pretty much I stick to the heart of the discussion being completed, hit it within 15 minutes. When that timer ends, the heart of the discussion ends. And sometimes it may not even reach 15 minutes. With that said, let's go ahead and get into today's topic. I'm going to start the timer here shortly, but before I start it, I do want to say that this particular topic was requested. It was requested by a few individuals, but one of my clients highly requested for me to share it. So I want to share this topic, and it is definitely timely. There's a class that I am offering called Decipher the Code Masterclass. It's a 4-part class where I deal with contracts, trademark, right of publicity, copyright. And the first class that is going to roll out on August 2nd is contracts. So this is a great topic that I'm going to discuss today. And the topic is on breach of contract. And what I want to talk about are some things that maybe people overlook, don't think about it. And I'm not even going to say maybe, because as a person who reviews tons of contracts, surprisingly, or maybe not, there are a lot of contracts that do not speak to this topic. So I do think it's more overlooked than it should be. So the request was actually good. It wasn't only timely. I think it's a good topic to drop some nuggets and to empower individuals with. So I'm going to get this timer started and set it for 15 minutes. And once we get into the heart of the discussion, I will hit the timer. And I'm going to do that now. So, breach of contract. First of all, let's start with the basics. And one thing that I've learned with dealing with so many people, diverse group of people, is never to assume that someone has certain knowledge and you start from the assumption of that, start from where you assume that someone's knowledge is at. You should always start from a place of giving a foundation. If someone says they know or they want, to move past whatever, then that's fine. But right now, no one can speak to me. I'm speaking to you. So I'm not going to share information based on the assumption that if you are listening, that you have any type of fundamental information or knowledge. So first of all, I want to start with that a contract is a document, or should be a document, that memorializes the concepts of any agreement that you have entered into with one or more people. So where a lot of people use the language interchangeably, which is contract and agreement, I kind of, depending on the conversation, make sure they stand alone. The agreement are terms that you come to meet somebody with, or you flush out with amongst somebody, but the contract is the memorialized version of that agreement, right? So that's how I'm looking at it. And not that a contract has to always be in writing. A contract can be in writing or it can be verbal. But when I say the contract is a document that memorializes the concepts of agreement, I'm talking about, literally on a piece of paper, whether it's piecemeal, via email, text. I always look at a contract as a document that memorializes that agreement. You could pull everything together to have a memorialized agreement. So both sides in an agreement should have rights and obligations. Both sides, right? There should be some type of exchange between the parties. Someone is benefiting and giving up something to get that benefit. Someone may have to perform in some type of way, physically perform. Someone may have to perform by paying, but there's rights and obligations that are exchanged. There is a bargain that was exchanged for between all parties. But if there's basic fundamental elements that you have to have present in order to create an agreement that is memorialized into a contract and having that contract enforceable. So another way, let me reframe that. There are fundamental elements outside of just saying, okay, I agree, you may flush out whatever those terms are to the agreement. There have to be fundamental elements that needs to be present in order to create what in legal world is called a traditional contract to be enforced. If those fundamental principles are not present, you may not have an enforceable contract. I won't get into all those details right here because there's a lot more that goes into the statement that I'm making. There's a lot of different things that have to be weighed against each other. There's the general rule, which means when you have a general rule, it's the general thing that governs certain actions. But then under certain circumstances, you may have an exception where that general rule is accepted. So I'm not going to get into that. But the general rule is there are fundamental building blocks or elements that you need to have present in order to make that agreement memorialize into a contract to be enforceable. And if you want to learn more about this information, as I mentioned earlier, I'm going to cover this information in my Decipher the Code DTC Contracts Masterclass that starts on August 2nd, 2021. If you can't attend live, there will be an opportunity for, access for students in the future, either on another cycle or in a modified version of what the live class was. But you can always visit learner.seekelevation.com. And but I'll get past that because we are on time. But I cover more information that's related to this topic also in segment 23, I believe it was, Contracting for Wealth, in segment 8, The Devil's in the Detail. So that's why it's important too to go back and listen to past segments so you can kind of hear, different information that you can build upon. And I will also cover more information on this topic in future segments too. So if the class is not something that you can do, you just keep coming to Seek Elevation and you'll more than likely come across the information. But the governing rules of a contract, right? Meaning the governing rules are provisions that you put in a contract. These are the actual provisions that has terms, clauses put in a contract that memorializes that agreement. Those governing rules are created through that language, and it should make a contract efficient in its communication on what needs to happen and what will happen if something doesn't happen. Because if you don't have that addressed in your contract, then you may leave that deciding factor, that decision if something happens or doesn't happen, that shouldn't happen, up to someone else. You'll leave it up to someone else to decide now what needs to be done because of those actions. And usually you're leaving up to a court. But it can be a court, an arbitrator, a mediator, someone outside of yourself if you have to pursue a situation where someone did or didn't do something that they're supposed to do to determine what will happen. And I always tell people the best time to discuss what would happen if something was not to work out is when everything is going great. That's the best time to have that conversation. Everybody's in the right mind. So you can talk about everything, talk about all the stuff that you want to go great. But also during that time, talk about if this, then that type situation. It's the same thing like in a marriage. You can focus on great marital, premarital counseling, all the great stuff, but also look at things like maybe prenups or just having those discussions on what if this doesn't work out. And having those discussions doesn't mean that you expect things to go awry. It doesn't mean that you are thinking negatively. This is what some people think. Like, why would we talk about that? I'm in this to win it. I'm not getting in this thinking about getting out. That's not the case. Listen, life happens. Life happens. You're being more accountable than you are being negative to think about a full picture. Actually, I strongly believe you do justice for whatever that relationship is, whether it be business or personal, when you look at it holistically and you think about it from the bird's eye view, and you think about it during a time when things are not just crazy. It just means you're being proactive. Like when I get in a car, right, I don't anticipate anything happening to me. I don't want to think negatively about me getting in a car and something happening, but I know anything is possible. Life happens. And so I'm going to put my seatbelt on. I'm not going to say I'm not putting my seatbelt on because I'm thinking negatively that if I put my seatbelt on, that I'm going to get into an accident. No, I'm getting there. I'm thinking proactively because, if anything does go wrong, then more than likely, I'm not going to be able to think rational in a situation. Anytime I go into huge bodies of water, if I'm going to go on a boat and I'm going to go on a great vacation, I want to enjoy my vacation. I don't want to think about what can happen, in this large body of water. If I step out there on the deck and something crazy happens, but things happen. So I'm going to put on my my life jacket if I'm on a boat. And I think, that's the best course of action for me to do. It's not about thinking negatively. It's about thinking proactively when everything is going right and not when you're put in a position and you can't think rationally. And that is exactly what happens when you look at contract dealings. You have individuals who may enter into a contract, and because they haven't spoken to what happened when things go wrong, then they become very irrational when the contract does not go the way that they expect for it to go. And then they have to involve the legal system, and they have outside people determining what will happen. And a lot of times there's people who have absolutely no recourse. There's absolutely no recourse at all. So, yeah, that's why I always tell people, have those discussions, especially when you're entering into a contract up front. And a lot of times, as I said before, I can tell those conversations were ignored, but they definitely weren't memorialized. So when someone doesn't fulfill their obligation, in the rest of the contract, you have rights and obligations for both sides. When someone doesn't fulfill their obligation, then that is said to be a breach. You're breaching a covenant. You're breaching that agreement. You're breaching that promise. And what happens if a person breaches that contract? If the person breaches that promise or covenant? That was the question. Well, that depends. Was it addressed in the contract exactly what would happen if someone breaches a contract? Was that addressed in the contract? And again, I just said earlier, I see a lot of times that's not addressed at all. I know you can't speak to every way that a person can breach a contract, but you can speak to an expectation that gives guidance to if someone breaches the contract, if someone doesn't fulfill the contract. That should at least be in your memorialized document. If someone doesn't fulfill their promise, will you seek damages? Will you go to a court to try to get damages, meaning money, or be put in a position, what they call in the legal world is to be put back whole, to be put in the position you was before the agreement. So will you seek that, any type of damages? Would it be in a court of law? Will it be with a mediator or arbitrator? What will it be? What choice of law? Which state will govern that particular breach? Is it the state that you all enter into the contract in? Is it some other state that you think will be more favorable to the type of business relationship you all are creating? Like for California, it might be better for entertainment. For New York, it might be better for business. I mean, what is the choice of law? What is the jurisdiction? These things have to be spoken to with a breach. Now, a lot of times people may speak to, if we have to decide something about a contract, then this is where we're going to decide it at. This is the jurisdiction. This is the choice of law. But you're still leaving it up to the court to decide if something happened. Still speak to the breach itself. Still speak to the breach, not just the jurisdiction who's going to govern, but will you give that person X amount of time to rectify it? If you don't speak to that, maybe a court of law said you should have given a reasonable time for someone to fix it. You have to define what that reasonable time is before someone else does. Will you give somebody reasonable time to cure that breach? Will you define what you consider something as being what is called a material breach, meaning it's heavy, it's to the core of this contract. If you don't do this or do this, it hurts the contract, versus something that's a non-material breach. If you don't speak to what's material, non-material, again, an outside person will. And you may not agree with it. You may say, this is what what this person did or didn't do, I consider that heavy. Well, you didn't speak to that in a contract. So again, if the ramifications of the breach, the type of breach, is not addressed, then the control is left up to an outsider. And it may or may not yield the result that, someone wants. So yeah, you want to definitely speak to it. But also, a court can side with the breach, right? Because the purpose of contracting, one of the purposes of contracting economically, is for efficiency. We have a right to enter into a contract to keep everything efficient, keep our relationship, the agreement moving efficiently, to enforce rights, keep that efficient. So your contract should be worded in a way that helps us encourage that efficiency. To not speak to breaching, it's not efficient for the court to handle it. They have to figure out how to handle it. So you want to make sure that you put what actions you want taking, or the parties want taken, for a breach. And a court can, again, side with the breach and find that the breaching of the contract is better than enforcing. Okay, that's time. But I will finish this thought. As I said before, we get to 15 minutes, we finish the thought. But a court can side with someone breaching a contract and find that the breaching of the contract is better than, enforcing someone to perform that type of contract. For efficiency, it's better to go ahead and breach and pay these damages than go forward or enforce someone to go forward with that performance. So if you don't speak to the breach, what the ramifications or the implications a breach may have to you, a court may find that a breach may be absolutely the best thing. That's why it's important to fill that gap. And they may even find, again, that the breach is not touching the material element of the contract, and you may feel that it is. But if you didn't speak to it, then they can make that decision. And to that point, quite often, when I don't see anything speaking to, the language surrounding a breach, there's also not language in a contract speaking to termination. There's a lot of times that people leave out a termination clause in their contract. And if you don't have a termination clause, a court may also find that it's more efficient to breach the contract because there was no other way out. You didn't speak to when does this contract end, or what are ways that this contract can end. Friendly termination. What are friendly ways that it can end? And they also don't even speak to hostile termination. So it's just best to go ahead and breach because it will be considered, that particular agreement may be considered, indeterminative. It could go on as long as whatever. So it's more efficient for economy to allow someone to breach. So there's a lot of things that have to be weighed on the benefit of enforcing performance or justifying a breach, and having someone just go ahead and pay whatever a fact finder, which is a court, mediator, arbitrator, whoever decides it's worth paying for that breach. So that covers that. The one thing I want you to take away from this is when you're reviewing a contract that you may enter into, or if you are drafting a contract, it will do you well to speak to how do you feel about a breach, what a breach is, what will happen with the breach, types of breach, if there's any type of recourse to cure the breach. And I know some people say, well, look, you can't stop, people from breaching or do whatever, but you can if you put in your contract that if you breach the contract, then there's certain rights that you have, maybe rights to content, rights to cancel something from happening. If someone breached a contract and they move forward with those things that you have listed can or cannot be done if the contract is breached, then you can have that cease and desist letter written. And now not only did the person possibly breach the contract, and you may have a claim with that, but they have also performed an unlawful act of something that they were not supposed to perform, especially, say, for instance, if it's content, copyrighted material content, for instance, and they can't use it, and you say that you have all the copyrighted rights or trademark rights or whatever, and they still use it anyway based on that breach, then you also will have a federal claim. So you still want to speak to whatever you need to speak to in a contract. You want to be forward thinking just in case things go awry, and that if a third party, a fact finder, have to make a decision, your memorialized document will help in making that decision. It will help and encourage and support our system being efficient. Well, that is it for today. I thank you for listening to another segment of Seek Elevation with Elakeisha, where ye shall seek and ye shall find. I want you to be educated, be enlightened, and be empowered. But most importantly, I want you to share. Please share the seeds. Yes, the more you know, the more you grow, but the more you share, the more we all glow. I was telling people previously to subscribe. Seek Elevation is on YouTube. Seek Elevation is on pretty much every podcast platform. But you know what? I really don't want to do that. If you are compelled to do so, by all means do it. But what's really more important to me is for you to share. Whoever's supposed to be connected is going to be connected. I truly appreciate the support, absolutely. But more importantly, I am giving. I'm giving. Whoever is supposed to align and get is going to align and get. So my focus is more on please share. And if you want to subscribe or do whatever additional stuff and feel compelled to do so, then by all means, you are welcome. But until next time, elevators going up. Thank you for listening to a segment of Seek Elevation. Seek and ye shall find. Until next time, be educated, be enlightened, be empowered.